Hi students, today's topic of discussion is Articles of Association, one of the twin important documents which guides the management of joint stock companies. Now let us see what is Articles of Association. It's nothing but a document which tells rules and regulations and bylaws for the internal management of the company. As I said you already, the two documents, Memorandum of Association and Articles of Association. Memorandum talks about the corporates dealing with outsiders and articles prescribes norms how internal management of a company should be conducted. Hope you followed what is Articles of Association. So actually this article is next importance to memorandum. So it contains fundamental conditions upon which the company is incorporated. Actually, which acts within the memorandum of association. No circumstances, articles can go beyond memorandum. So, articles of association is subordinate to and also controlled by memorandum of association. So, as I said, it must not violate the memorandum and act. Now, let us see what are all the contents of articles regarding share capital. So, regarding share capital, articles tells about rights of shareholders. What is the jurisdiction within a shareholders can act, and also it gives variation in these rights. Whenever there is change in shareholders' rights, it should be incorporated in articles of association, and also it talks about management commission and also share certificate, then rules and regulations regarding lien on shares and also call on shares. Next, it also tells about transfer of shares, rules and regulations regarding transfer of shares, transmission of shares, forfeiture of shares. It means when a share can be forfeited and what the terms and condition, ratio of forfeited shares. All these are included in articles of association. Then when shares can be converted into stock, regarding share warrants, and also the most important one is alteration of capital. You know that it cannot be altered as such. So articles of association speaks about how a company's capital can be altered. It also tells how a general meetings of a company can be convened and proceedings regarding the general meetings. The most important part of joint stock company, voting rights of share members or shareholders, how a voting and poll can be convened, how a proxy can be nominated by the shareholders, rights and duties of proxies are all included in the articles of association. Then next it also tells about a management aspect of company. Students, you all knew that a company is there managed by board of directors. So it prescribes about the appointment of directors, their remuneration, qualifications, powers, and proceedings of board of directors. It also tells about how a manager can be appointed, their remuneration, their qualification and all. Then secretary, the important person of a company, act as a liaison officer between a company and all the stakeholders. Then regarding the dividends, the purpose for which the shareholders enters the company. Regarding how a dividend can be declared, all the norms regarding dividends and also the reserves, how a reserve can be created out of profit, the percentage of reserve, how it can be utilized, everything will be decided and given by the articles of association. And also about the statutory duty, accounting, maintenance of accounts, auditing of accounts, and also borrowing powers of the companies. Whenever a company want to the capitalize its profit, the norms regarding capitalization of profits also specified by the articles of association. You all knew that company is an artificial person created by law. Nothing but Indian Companies Act 1956. It's a constitution upon which the company acts. Even the articles and memorandum relies on that Companies Act and its amendments to draft its articles and memorandum. So, as I said, a company is an artificial person created by law, and it put an end of a company is also decided by a legal term. So, it should be the article should specify or prescribe the winding up procedure. It means how legally we are putting an end to a functioning of a company. That also given by articles of association. So now let hope students, you hope you understood about the basic part of articles of association. What is articles, what it contains, and other things regarding internal management of the company. Now let us see about model form of articles. Actually, Schedule 1 to the Companies Act prescribes or gives different formats of articles. Actually, Table A provide rules and management for companies limited by shares. Table B gives model memorandum of association limited by shares. Table C provide a model of memorandum of association and also articles of association for those joint stock companies limited by guarantee and not having share capital. Table D for companies limited by guarantee and also having share capital. Table E provides rules and regulations for memorandum of association and also articles of association for unlimited companies. So this part tells you that there is no single format of memorandum and articles for all types of companies. Companies Act prescribes different format for different set of companies, different type of companies. So, usually companies are limited by maximum of or majority of the companies are limited by shares. They should adhere to table A. In case of those table B gives both memorandum for both the table B gives memorandum for those companies limited by shares, as I said. Then for companies not having share capital and limited by guarantee should refer table C. Then those companies which have capital but limited by guarantee should rely on table D. Then unlimited companies should follow table E for drafting memorandum and articles of association. So, is it compulsory? Now the question will arise. What type of companies should have articles, their own articles? So, the following types of companies must have their own articles of association. Unlimited companies, companies limited by guarantee, and private companies limited by shares. Actually, these articles of association must be subscribed by. It means that signed by. Subscribed by means signed by the subscriber to the memorandum. It means that articles of association should also signed by the persons or subscribers or those who signed in the memorandum of association, and it should also registered the register of companies along with memorandum of association. In the case of public companies, they must have own articles of association. If else, suppose they don't want to have a separate articles of association, then they can adopt Table A, Schedule 1 to the Companies Act. Now let us see about alteration of articles. Actually, companies are given power with alter the articles. So, what is the procedure for alteration of articles? Actually, all the activities of a companies are ratified by resolution, either by special resolution or by ordinary resolution. In that case, you want to alter the articles, it must be ratified by a special resolution, and that any changes ratified or approved by the special resolution should be forwarded to the registrar of companies within 30 days. With the altered copy must reach the registrar office within 30 days.